Welcome back to Counting to Five, a podcast about the United States Supreme Court. I'm Mike, your host, and this is our weekly YouTube live stream being broadcast live Thursday, April 12th, 2018 at 9 p.m. Eastern Time. And this live stream will also be posted as an episode of the Counting to Five audio podcast. If you're watching live, please feel free to ask questions in the YouTube live chat at any time. I'll try to monitor that and periodically answer any questions as they come up. In these weekly live streams, we keep up to date with the latest Supreme Court news, and here's what I plan to cover today. This was a quiet week at the court. The court has been in recess between its March and April oral argument sessions. So there were, since last week's live stream, there were no, the court did not have a conference. That means there's no new orders list, no new cases granted for next term, and there have been no new opinions. So pretty quiet. Next week, however, the week of April 16th, the court will be hearing oral argument in 6 cases. So the main focus of tonight's live stream will be to give a preview of each of those 6 cases that are going to be argued from Monday to Wednesday next week. But first, before we get to that, a quick look at some of the week's other Supreme Court related news. The first thing I wanted to touch on very briefly is just a minor milestone this week. On Tuesday, that's April 10th, that marked Justice Neil Gorsuch's 1-year anniversary on the court. A year ago, April 10th was when he took the oath of office and was sworn into the court. So unsurprisingly, that's prompted a lot of reflections and writing about his first year on the court. The general consensus so far is no real surprises. Justice Gorsuch has performed more or less just as was expected. Of course, there's a huge divide over whether that's a good thing or a bad thing, depending on where people stood on Gorsuch at the time of his confirmation hearings. He has, in his role as the new justice on the court, he has very kind of self-consciously positioned himself as a constitutional originalist. That is someone who believes the Constitution should be interpreted according to its original meaning, and as a textualist, that is someone who believes that when interpreting statutes, the meaning of the specific language used by Congress takes precedence over things like the general statutory purpose or the legislator's intentions. And those are the positions that he advertised very prominently during his confirmation hearing. So again, no surprise that he has kind of really stuck to this position in his first year on the court. As expected, he has also tended to side with the court's more conservative wing in those cases that do divide along these kind of ideological lines. And that places him most often in the company of Justices Thomas and Alito. Justice Thomas being generally considered the most strongly originalist justice on the court. Justice Alito, by contrast, doesn't really identify as an originalist, but he's often considered to be the most conservative justice on the court in terms of political ideology. A few things to keep in mind when looking at this first year is as far as the opinions go, we really have a pretty small sample size so far. The court's work tends to be backloaded toward the end of the term. They start hearing oral arguments in October, and they hear arguments from October through April, but a large number of opinions are issued in the last 2 months of the term, in May and June every year. So this year, even though we're already into April and we're about to begin the last argument sitting of the term, the court has only issued a pretty small portion of its total cases. It's only gone through a little more than a quarter of the expected cases it's going to decide for this term. And last term, Gorsuch was only on the court for the last argument session, the April argument session, and only had one majority opinion out of that. This term, he's only issued 2 majority opinions so far this year, which puts him in the same ballpark as other justices so far. But based on the numbers and the fact that the majority opinions tend to be roughly equally divided among the justices, we should expect about 5 more or so majority opinions from him in the next 2.5 months. So that would almost triple his current output of majority opinions. So we'll have a lot more to go on by the end of the term. Last term, in that last argument session that he was sitting on last term, Justice Gorsuch issued an unusually high number of separate opinions, that's separate concurrences and dissents. One possible explanation for that last term was just that he had a lot of time on his hands. He was there on the court. His colleagues were all working on their backlog of cases from earlier in the term, but he had only one majority opinion to deal with, and had a lot of time on his hands to write those extra opinions. So far this year, that he doesn't look like he has a particularly an unusually high number of concurrences and dissents, but again, that may change as we get toward the end of the year and more of the opinions come out, especially if there are more, as is often the case, more of the closely divided opinions that really divide the court coming down toward the end of the term. Looking at the opinions, the decisions that Gorsuch has issued so far, his three majority opinions, two of them were unanimous. His first opinion last year was a unanimous opinion, statutory interpretation issue. He also had a unanimous opinion in one of the court's original jurisdiction cases. Those are cases that are filed directly in the Supreme Court, and this was a water rights case between Texas and New Mexico. That was a case that didn't really get much attention or interest either. He did have one closely divided majority opinion, a 5-4 case where Justice Sotomayor was in the dissent, or wrote for the dissent, and that was a statutory interpretation case called Murphy. But a few other cases are interesting just because they may give some indication of where he differs from Justice Thomas, who is again his closest ally on the court so far. Earlier this term, there were two cases, both criminal law cases. One was a case called Class v. United States, which was a criminal procedure case about the effect of guilty pleas on the right to appeal. And in that case, he was in the majority in that case, 6-justice majority, while Justices Alito, Kennedy, and Thomas were in dissent. So he was, in that case, Justice Gorsuch sided with the justices finding for the criminal defendant in that case, and Justice Alito and Thomas were on the other side. The other case, called Marinello v. United States, was a criminal law case about the interpretation of a criminal provision of the tax code. And here, Justice Gorsuch was in a 7-justice majority with Justices Thomas and Alito, again, in the dissent there. So one area where he has distinguished himself from Justice Thomas in particular this term is in this criminal area where at least so far, it appears he's more sympathetic to the rights of criminal defendants so far. So that's an interesting area to watch going forward. Now, of course, with the small number of opinions that he's cases that he's been involved in so far, there's many areas of law where Justice Gorsuch hasn't joined any opinions yet. There's no cases have come out that he's been involved in, and there's many more areas where he hasn't written anything yet. Even if he's joined on to an opinion by someone else, he hasn't written on his own. And so there's a lot of areas of law where it'll still may be a while before we have a really fleshed out sense of Justice Gorsuch's views and where he comes down on various legal issues. A few other interesting things to watch for going forward. At the earlier this term, there were rumors that were getting a lot of attention about allegedly sharp conflicts that Justice Gorsuch was having with several of his colleagues, but especially Justice Kagan. And the rumors were suggesting that he had through his behavior on the court so far was alienating some of his colleagues and really coming to some sharp disagreements with Justice Kagan. I think so far there's reason for skepticism about these reports. They were anonymous and really unsourced. And in fact, there were almost identical rumors floating around about other justices when they newly joined the court, including Justice Kagan when she joined, which appear to have been completely unfounded later on. And no one talks about those supposed clashes with Justice Kagan anymore. And also, Justice Gorsuch had a long track record of judicial experience. He served for more than 10 years on the 10th Circuit Court of Appeals, which was an ideologically diverse court. Had almost a roughly even split of appointees from Republican presidents and Democratic presidents. And he was apparently well liked by his colleagues on that court, and there was no reports of any real personality clashes there. Now, it's always possible that he rubbed some of the justices the wrong way, but there's just no real strong evidence one way or the other so far. But it's something to keep an eye on as things go forward and more opinions start coming out of the court, and we might get a better idea of where the justices are lining up and see if there's any particularly strongly worded opinions either from him or from one of his colleagues directed at each other. There's been speculation recently. One of the notable things about this term has been the slow pace of opinions. The court is kind of behind its typical output at this point in the year and has quite a few opinions that it still has to hand down in the remaining weeks of the term. And some have speculated that the one big change is the addition of Justice Gorsuch, and that maybe he has something to do with this slowdown, which could potentially be because he's writing a large number of separate opinions, concurrences, and dissents that might require more response or back and forth with the other justices. Maybe he has engendered more sharp disagreements because of the specific legal positions he's been taking that require more back and forth and more drafts and responses. Or this could be, again, this is pure speculation, could be completely unfounded. Again, at the end of the term, maybe we'll have a little better sense when we see the opinions coming down and we see where the whether he does have a lot of separate opinions, whether there do seem to be a lot of particularly sharp disagreements. But it's just something to watch for. One particular area that will be particularly interesting to watch for is the Fourth Amendment, the protections against unreasonable searches and seizures. The court has heard several Fourth Amendment cases this term, and we're still waiting on opinions from them. There was one case called Carpenter about cell phone tower location data, whether the government needs a warrant to obtain that. And there were two cases involving automobile searches. And at oral argument in all of these cases, Justice Gorsuch was really seemed to be pushing a property rights-based approach to the Fourth Amendment, to deciding the reach of the Fourth Amendment. Now, this is an approach that some justices have kind of played with in the past, including the late Justice Scalia, who decided some opinions along those lines. But it is different from kind of the court's standard approach in these Fourth Amendment cases, which usually focuses on what the court refers to as the reasonable expectation of privacy. And so it'll be interesting to see what happens with this case and whether Gorsuch pushes for more opinions that use this property rights based type of reasoning. If this view does gain any traction on the court, a move away from the reasonable expectation of privacy toward a more property-based approach could have some pretty big implications for Fourth Amendment law. It'll be interesting to see if anything comes of that. In some of those arguments, also these Fourth Amendment arguments, Justices Gorsuch and Sotomayor seem to be very much in sync with each other in terms of their questions to counsel. And so it'll be interesting to see whether that shows up in the opinions as an interesting little alignment. And again, we'll have a better sense at the end of the term if any of these dynamics that seem to be at work in the oral arguments, if they actually play out in the way these cases get decided. So that's just some brief thoughts about Justice Gorsuch's first year and things to think about going forward. One more brief update relates to the travel ban litigation. This is the litigation related to the Trump administration's ban on nationals of certain countries entering the United States. And earlier this week, that on Tuesday, April 10th, one of the countries that had been listed on the travel ban list of countries whose nationals were restricted from entering the U.S., it was Chad, the African nation of Chad, on Tuesday this week, it was removed from the travel ban list. So nationals from Chad are no longer barred from entry under the travel ban. Now, Chad had been added. It was kind of a late addition to the travel ban countries. It was added in September in what's been referred to as Travel Ban 3.0, the kind of third revision of the travel ban orders. And that is the version of the travel ban that is currently being challenged at the Supreme Court. And so it's just, this is an interesting development shortly before the oral argument in this case. The addition of Chad to the banned companies had been cited by some as evidence of problems with the travel ban country designations. Chad had been, it was kind of a surprise because it was a major ally in Africa in the United States' counterterrorism efforts. And it was allegedly added to the travel ban, at least in part, due to actually a shortage of passport paper, which prevented Chad from supplying the United States with sample passports. Now, the United States has also said that there were other factors involved as well, but that was supposedly one of the factors was a paper shortage that led to the country being added to this list. However, it's likely also that supporters of the legality of the travel ban will point to this as evidence of the effectiveness of the periodic review called for in the travel ban, that countries that are on the travel ban can be removed from it after being reviewed periodically. But in any case, the travel ban litigation is going to be argued on April 25th at the Supreme Court. That's the last day of oral argument for the term. And I'll be discussing that litigation more next week when I preview the second week of April oral arguments. So with that out of the way, let's move on to next week's cases. As I said, there's 6 cases. There are 2 each day from Monday through Wednesday next week. And so I'll just start at the beginning and work through each of these 6 cases and talk a little about what's coming up next week. So the first case that the court will be hearing on Monday is a case called Wisconsin Central v. United States. And this is a case about there's a statute dating back to the Great Depression called the Railroad Retirement Tax Act. And this is it's a statute that's the railroad industry's equivalent of the FICA Social Security taxes that are paid by most workers in the United States. Employees of the railroads pay, instead of paying FICA taxes, they pay taxes under this Railroad Retirement Tax Act, or RRTA. And it is similar to FICA in many ways, in that the employers, the railroads, withhold money from paychecks that go into a retirement fund. However, there's different language than Social Security with respect to the basis for the tax withholding. So the more familiar FICA, it applies to wages, which are defined to include all remuneration for employment, including the cash value of all remuneration, including benefits paid in any medium other than cash. So there's a very broad definition of what wages means. And basically in-kind benefits and things like that count as wages and have to be valued and taxes withheld on the basis of taxes have to be withheld to account for those benefits. Now, the RRTA has a different statutory language. Instead, it requires withholding a percentage of employee compensation, and then compensation is defined as money remuneration. So the question here is how broad is the term money remuneration? And the specific question here is, does the exercise of stock options count as money remuneration? And how this came up is the railroads have sued the government for a refund of taxes paid on exercise stock options. So the government has said that these exercise stock options, when someone exercises stock options, then that counts as money remuneration, and the company has to withhold taxes on the basis of that, and that's been challenged. And the railroads have argued here that the difference in language between the RRTA and FICA is crucial, and the RRTA does not unlike FICA, does not explicitly include benefits. And so they argue that money remuneration just doesn't include non-monetary things like stock. They say that the word money needs to be given some meaning. If they could just say remuneration, if this was meant to be broad and include any kind of equivalent, but by including the word money, that necessarily limits it to something less. The government argues on the other side that basically stock is basically a cash equivalent. It's easily valued and converted to cash. They also say that there's been basically over time a convergence between FICA and the RRTA, and there's been an intent that as much as possible these statutes should be construed to be in sync with each other. They've been amended over the years to be more similar. And the government also points to an exception to in the RRTA, an exception that's specifically in the statute for what's known as qualified stock options. Now, qualified stock options are a type of option granted exclusively to employees that have special tax benefits. Those are not the type of stock options at issue here in this case. But the argument is that given that Congress had enacted a specific exception for qualified stock options, that implies that non-qualified stock options must be covered by the phrase money remuneration, or else that would have been unnecessary. Now, the railroads argue on the other hand, they say that this later added exception for the qualified stock options doesn't change the basic meaning of money remuneration. And they also make an argument that these qualified stock options can sometimes involve cash payments as well as the stock. For example, if there's a partial share that someone is entitled to under a qualified stock option program, they may be paid in cash, and that the Congress may have been wanting to cover that. So there's arguments on both sides about the scope of this money remuneration, and that's what the court's going to be figuring out in that case. Now, the next case, the second case that's going to be argued on Monday, is a patent law case, a case related to damages in patent law, and it's a case about extraterritoriality, and that's what effect U.S. law has outside for actions that are happening outside of the territorial United States. And this is a case. It's called I don't know the pronunciation of this case. Western GECO v. Ion Geophysical Corp. I've heard it pronounced Western Gecko, but based on the history of the name, I think it's likely Western GECO. We'll see. But it's the issue here is patent law is generally territorial. Different nations have their own patent procedures. And if a company inventor wants to obtain a patent, if they obtain a U.S. patent, in general, it only protects against patent infringement in the United States. If you want your invention to be protected elsewhere, you have to also seek a patent in those other jurisdictions, in Europe, in Japan, and other important patent jurisdictions, to get protection in those places as well. And so if someone has a U.S. patent and someone outside of the U.S. creates a copy of their invention, there's no claim of infringement. However, there's a exception here. You can't create an infringing product to sell abroad. The creation of that product in the United States, even if it's being sold abroad, is still infringing. Now, in order to prevent circumvention of that rule, there's a specific provision. There's two provisions that are really at issue here in this case. But the first is a provision that's called Section 271F of the patent code here, and the relevant language here is: whoever supplies from the United States all or a substantial portion of the components of a patented invention in such manner as to actively induce the combination of such components outside of the United States in a manner that would infringe the patent if such combination occurred within the United States shall be liable as an infringer. So in other words, if you create the components of a patented invention and then just ship them out of the United States to be combined into that patented invention outside the United States, then you're liable just as you would be if you had created the infringing product completely within the United States. Now, the issue here in this case is another provision called Section 284. And the language here is, the court shall award the claimant damages adequate to compensate for the infringement, but in no event less than a reasonable royalty for the use made of the invention by the infringer. So that's the damages provision. So it says damages adequate to compensate for the infringement, no event less than a reasonable royalty. So the issue is, normally, let me give a little factual background in this case, and to kind of set this up. So this company, Western Geco, has patents on technology that's used to map the ocean floor. Now, this is used for oil and gas exploration primarily. They have these equipment that gets trawled behind a ocean, and it maps the ocean floor, and then that data that it generates can later be used to try and determine likely places to drill for oil and gas. But this company didn't sell or license its technology. Instead, it performed these ocean floor surveys itself. So it had its own ships that it used to survey. So it would contract with oil companies, for example, to perform these surveys to look for places to drill. Now, the other company involved in this case, Ion Geophysical, they created an imitation system, a system that basically did the same thing. And they shipped the components of the system from Louisiana. They shipped these components abroad to be assembled into an infringing system. Now, as I noted above, this is infringement under Section 271F by shipping the components to be assembled abroad. That qualifies as infringement under that provision. But the issue here is, what kind of damages are available under this? Now, normally, if someone in Western Geco's position, someone who uses its own technology to generate profits. So here they were contracting to perform these ocean floor surveys. If someone else stole their technology, say it was domestic, someone else within the United States copied their technology and was performing those surveys, they would be entitled to a royalty, a reasonable royalty for the use of the patent, but they would also be entitled to lost profits for the surveys that they lost out on, the business they lost out on because someone else who stole their patent took their business away. So the question here is, what about in this case where it's international? Are those lost profits still available? So no one is disputing here that they're entitled to reasonable royalties for the actual patented invention. But the question is, what about the lost profits due to Ion Geophysical's use of this technology to get contracts that might have otherwise gone to Western Geco? And the argument here is, on one side, the argument is the statute says it provides damages adequate to compensate for the infringement, and the foreign profits were derived from the infringement, so that they should follow just as if this was a domestic infringement. The argument on the other side goes to something called the presumption against extraterritoriality. And what this is the presumption against extraterritoriality is a rule of interpreting statutes that says basically laws are presumed to only apply within the United States unless Congress specifically specifies otherwise. Now, this is just a presumption. It's not an absolute rule, but it recognizes that governance is very territorial in nature. Usually when Congress passes a law that's regulating certain type of behavior, that's barring someone for doing something or regulating exactly how certain actions have to be taken, it's assumed that they're talking about in the United States. They're not trying to regulate the entire world anywhere and everywhere. Sometimes Congress is trying to reach broader, but they generally will specify when that's the case. So this presumption, there's a presumption that when a statute doesn't say otherwise, it only applies within the United States. Now, the argument here by Ion Geophysical is that this damages provision, Section 284, this presumption against extraterritoriality should apply. So that lost profits shouldn't apply to lost profits from outside of the United States under this provision. Now, Western GECO argues that this presumption against extraterritoriality shouldn't apply here, because the underlying liability provision, that 271F provision that says that the Ion Geophysical is liable for the infringement, that already explicitly deals with the extraterritoriality issue, and the damages provision just follows from that. On the other hand, Ion Geophysical argues that the lost profits here result entirely from foreign conduct. Yes, the components were shipped out of the United States, and that's clearly covered by 271F. They were shipped out of the United States to be assembled into an infringing product abroad. However, the lost profits came from entirely foreign conduct, foreign bids for survey work that was separate and followed after the infringing shipment of the components out of the United States. And so they argue that in order to pull that entirely foreign conduct into the damages calculation, Congress should be required to clearly speak to whether this is supposed to cover foreign conduct. One issue that kind of the Ion Geophysical brings up here is a concept known as comity. That's comity with a T, COMITY. That's the idea of the kind of the respect that's owed by one nation or one legal jurisdiction toward other legal jurisdictions. When laws are applied extraterritorially, that can result in conflicts of law or conflicts of policy between two different jurisdictions. In this, patent context, for example, certain U.S. inventions might not be patentable in foreign jurisdictions. The patent laws are in different jurisdictions of the world are not exactly the same, and something that's patentable in one place may not be somewhere else. Also, foreign jurisdictions may have different measures of damage or different legal procedures for determining infringement. So the argument is that important reason for this presumption against extraterritoriality is to avoid these types of conflicts, and that the concept of comity, there is this respect for other nations, suggests that it kind of counsels against an interpretation or application of U.S. law that would cause conflicts with foreign law or policy. And Ion Geophysical argues here that the plaintiff's argued approach, Western GECO's argued approach here, would allow someone to bootstrap a minor U.S. infringement into global damages that they wouldn't otherwise be entitled to. And they give an example. For example, if there was a company with a U.S. presence who prototyped an infringing invention in the United States, so an invention that infringed a U.S. patent they prototyped in the United States, but they later manufactured and sold that invention completely outside of the United States. So manufactured and sold it, for example, inside Korea. Would that company be entitled to damages for infringement, even if, for example, Korea had looked at that same patent application and had denied a patent on that invention, finding it not patentable in Korea? Would they still be entitled to all of these damages because they follow from the U.S. Infringement in the first place? So that's kind of the argument they make, that this damage provision should be seen as a separate instance that requires the application of this presumption against extraterritoriality. So that's the issue there. So moving on, let's go to the next case. On Tuesday, the first case on Tuesday is a case called South Dakota v. Wayfarer. Now, this is a case that's gotten a lot of attention. It's a case that's explicitly asking the court to overturn a previous case from 1992 called Quill Corp v. North Dakota. And what this case deals with is the taxation of sales taxation of internet sales. Now, this 1992 case, Quill, the court held in that case that states can't require retailers that had no physical presence in the state to collect state sales tax. And that was actually based on an earlier case, a 1967 case called, it was called National Bellis Hess v. Department of Revenue. And this is under, it's a doctrine known as the Dormant Commerce Clause. And just briefly what this is, the Commerce Clause is a provision in the Constitution that gives the federal government the authority to regulate interstate commerce. Now, the Dormant Commerce Clause is something that an idea that says, by implication, because the federal government has this power to regulate interstate commerce, the states are prohibited under this concept called the Dormant Commerce Clause. That the states are prohibited from impeding this interstate commerce, even if Congress hasn't specifically acted in a particular area. And so under this concept, they said that when a retailer has no presence in the state, that the state is not allowed to require them to collect sales tax. Now, what states do generally, states that collect sales tax, in order to collect taxes on these out-of-state sales, they actually impose. Typically, most states will impose a tax on state residents to pay a use tax. So anytime a state resident purchases something from out of state and doesn't pay sales tax on it, technically they're supposed to pay a use tax to the state that's basically equivalent to what they would have paid in sales tax. In practice, these taxes are extremely rarely paid. Most people who buy things from out of state never pay these use taxes, even if they see the spot for that on their state income tax forms that requires them to pay this use tax. Most people never pay that. It would be incredibly burdensome for the state to try to enforce that. And it would be incredibly politically unpopular if they took any aggressive actions to enforce that. For example, by trying to audit residents' credit card purchases in order to find out if they've been buying things from out of state that they need to pay taxes on. So in practice, the states just don't collect these taxes from these out of state purchases. So what happened here is South Dakota passed a law to specifically challenge this quill rule, and a number of other states have done the same thing to a greater or lesser degree. Have passed laws that seem to conflict with what is allowed under quill, but there's a belief that the court may be ready to reconsider quill and overturn it. Now, the South Dakota's law is limited. It doesn't apply to all out-of-state sales. First, it only applies to retailers who have either $100,000 worth of sales into South Dakota or at least 200 separate sales. And so in that way, it doesn't burden businesses that have a very small South Dakota footprint. And it also prohibits a retroactive application. So in South Dakota, they're not allowed to go after retailers for back taxes under this theory. And the theory here is that quill is outdated and should be overruled. And the idea is that quill was decided in the era of mail order catalogs. It was before there was any. It was 1992, so there was no e-commerce basically, and mail order catalogs. It was just far less significant in terms of quantity. And there's been a lot of changes since quill that kind of undermine that position. First, there's been the explosion of e-commerce, which has caused a hit on state tax revenues and also a big economic impact on certain brick and mortar stores. The second argument is that the burden of collecting these sales taxes by out-of-state vendors is a lot less now because there are off-the-shelf e-commerce technology solutions in order to calculate and collect sales taxes. So you can buy software that can kind of plug into your e-commerce website and allow it to calculate sales taxes. And also, there's been some movement toward harmonization between different states and across and between states and localities to try and have a little more uniformity over how various different goods are categorized in terms of what type of sales tax is paid on them. That's still only very partial, and there's a lot of differences from state to state and even within states, but there's at least been movement toward that direction. Now, the argument on the other side, one of the main arguments is it's something called stare decisis. That's just a fancy legal term for respecting existing precedents, for the idea that precedents should be allowed to stand. And the argument here is, there's a few arguments, but as I mentioned, this is under the Dormant Commerce Clause. Now, even though the Dormant Commerce Clause, this idea that states can't act to impede or obstruct interstate commerce, even when Congress hasn't acted, that even though it's kind of derived from this constitutional provision, in this area, Congress has the authority to step in and override any of these things, because it's based on the presumption that Congress wanted to leave the free flow of commerce. But Congress can always step in and say that they specifically authorize states to do this, for example. And the argument is, especially in those cases where Congress can step in and change things, this respect for precedent has a more force. Congress has done nothing to change this in the 50 years or so that this rule has basically been on the books, and so the court shouldn't step in to change the framework when Congress has shown no inclination to do so. And also they argue that there's a lot of reliance on this by businesses. Businesses have invested and designed their business models on the basis of this understanding, including things like their location of physical facilities and their e-commerce infrastructure. There's also been some interesting more recent shifts in e-commerce. It's been noted that there's a renewed importance of physical location by many businesses. So it used to be the case that big online retailers like Amazon were very careful about where they located their warehouses, because they wanted to avoid placing those warehouses in states that collect sales taxes, so they didn't have a physical location requiring them to collect sales taxes. Now, due to the customer's demand for prompt delivery and the much more focus on very short same-day delivery, next-day delivery, things like that for various types of products, physical location has been much more important. Amazon now has physical facilities in many more locations. Amazon has also started opening physical locations. They have actual Amazon retail stores, and they recently purchased Whole Foods to enter into the supermarket business, and that gives them even more physical locations. And Amazon now collects sales tax in every taxing jurisdiction. So while many people think of this Quill issue as a Amazon thing, whether Amazon collects tax, Amazon in fact already does collect tax, and they wouldn't be directly affected by this change, at least for their own sales. And there's also been a large entrance of major brick and mortar businesses into the e-commerce space. So, huge e-commerce sites include, for example, Walmart and Target, which obviously have physical locations everywhere. By one count, 19 of the top 20 e-commerce sites have physical presences such that they already collect sales taxes in every taxing jurisdiction. So really, this is more about the smaller scale sellers. Those are the people who are not currently covered by the physical presence requirement. And so the basic legal argument is that by South Dakota is that the physical presence rule is at odds with the Supreme Court's general Dormant Commerce Clause rules. That the usual test is whether a state is discriminating against out-of-state businesses or if they're placing undue burdens on interstate commerce. And according to South Dakota, under that typical rule, this tax, the imposition of these taxes would be perfectly fine. The Wayfarer, the company that's been challenging this tax, argues they make several arguments. First, they say that in fact the argument that the software solutions solves the burden problem is not true, that there still is a very significant compliance burden. There's something like 12,000 different taxing jurisdictions in the United States. And this is from their brief. They say, including not only cities and counties, but also parishes, stadium districts, transportation districts, water districts, scientific and cultural facilities districts, and police jurisdictions, among others, which often do not correspond with zip codes or even municipal or county boundaries. And they note that there are also very different product definitions from state to state. Some states have a number of different categories of goods that have different tax treatment, and those categories are not consistent from state to state. They have different exemptions, different definitions of exemptions, and different rules that have to be followed as far as documentation for when a particular purchaser, like a charity, is exempt from sales tax. There's different tax holiday rules that from state to state and even within states. And also there's very difficult questions about the sourcing of online services and digital products to a particular taxing jurisdiction. So when someone purchases, for example, just a purely digital product, a song or a game or something like that, how do you decide where that is for purposes of taxing it? Or a cloud computing service, for another example, where does that exist for purposes of taxing? And that's a kind of an unsolved problem. In many states don't tax many services for this very purpose, but South Dakota has stepped into demanding tax on internet services. And so they argue that this is this significant compliance burden, and they also push back on the argument that there won't be this retroactivity problem. That they say that several states have already brought actions seeking back taxes under the same theory that South Dakota is putting forth here. So just because South Dakota has this protection doesn't mean that every place will. So they've raised these various arguments, but mostly they're relying on this stare decisis, this precedent argument. But that's the basic arguments going back and forth in that case. So moving on, the second case that'll be heard on Tuesday next week is called Lamar, Archer, and Coffrin LLP v. Appling. And this is a bankruptcy case. It's about a specific provision of bankruptcy that it's an exception to the discharge of debts in bankruptcy. Now, the basic idea of bankruptcy is that when someone files for bankruptcy, the process is designed to identify all of the debts, satisfy some portion of those debts by liquidating assets, and then discharge the rest of the debts to give the debtor a fresh start. But there's exceptions, and certain things are not dischargeable. And an issue here is a provision of the bankruptcy code that says there's no discharge. And here I'll read part of the provision: no discharge for money, property, services, or an extension, renewal, or refinancing of credit to the extent obtained by false pretenses, a false representation, or actual fraud, other than a statement respecting the debtor's or an insider's financial condition. So the general idea here is if you have a fraudulent debt, it can't be discharged. So if you have a debt that's obtained by fraud, then you can't discharge it. You keep that even after the bankruptcy proceedings are finished. You still owe that money, and it doesn't get wiped away. But there's an exception, and that exception is when the fraud was respecting the debtor's or an insider's financial condition. Now, why did this exception exist? Well, what the parties say is basically there was a concern in Congress about a practice by lenders who would induce a false statement about finances in order to basically shield themselves from having the debt discharged in bankruptcy. So that they were going to lend money to someone for a mortgage or for something else or whatever, and they would encourage the borrower to make what they knew to be a false statement about the borrower's financial condition, to claim they had more assets than they did or more ability to pay back than they did, so that if the borrower ever declared bankruptcy, the lender could then come in and say, oh, this is non-dischargeable because of the fraud. So this exception apparently was placed in there for that purpose. So the question here is, what counts as a false statement respecting the debtor's financial condition? What about fraud that's related to the overall financial condition, but that isn't directly about that overall financial condition, but is related or implicates it? So here, the issue was a false statement about an anticipated tax refund in order to get a extension of credit. Here's the basic facts here. The Appling, that's the debtor here, retained a law firm for litigation related to a business that he owned. He fell behind on his monthly payments to the law firm, and at one point in discussions with the firm about being behind on these payments, he claimed that he was expecting a tax refund of about $100,000 from an amended tax filing he had made. And he said he was basically had earmarked this tax refund to pay legal fees. And then he strung the firm along for a while as they pressed him on it. In fact, he did receive a tax refund, but it was only about $60,000, not the $100,000 he had claimed. And he immediately spent that $60,000 on other business expenses, didn't use it to pay back the firm. So the law firm sued, and Appling had filed for bankruptcy. Appling argued that the debt to the firm was dischargeable in bankruptcy. The firm said, no, it's a fraudulent debt, so it's not dischargeable. Appling said, no, the fraud was related to his financial state. It was respecting his financial condition, so that falls under that exception. It is dischargeable. And the firm argues, no, it was related to a specific source of funds, the tax refund. It wasn't related to your overall financial condition, so it doesn't fit within that exception. Now, Appling argues in this case that this broad reading of the exception serves the purposes of the act. The whole reason the firm cared about the refund and the size of the refund is because they cared about Appling's overall financial state. That was a data point that this $100,000 he was going to be receiving, allegedly, that gave the law firm information about his financial condition, his ability to pay the fees that he owed them. And Appling argues that the firm is seeking an end run around another provision. Now, I mentioned that there's this exception for fraudulent debts, but not fraudulent debts relating to respecting the financial condition. There's another provision of the bankruptcy code immediately following it that also makes non-dischargeable debt that was secured by the use of a statement in writing, a materially false statement in writing respecting the debtor's financial condition, on which the creditor relied, that was made with the intent to deceive. So it covers basically the same thing, but it requires a statement in writing. Now, that didn't exist in this case. There was no, Appling had put nothing in writing about this supposed $100,000 refund. So under this other provision, it wouldn't qualify. There's no statement in writing, so it wouldn't qualify there. And Appling's arguing basically they're trying to do an end run around that by reading the exception to non-dischargeability for statements about a financial condition, reading that incredibly narrowly to cause this to still be non-dischargeable, when normally they would have to jump through these other hoops, including having it in writing. And they argue that this case is a good illustration of why these requirements are important. Here, the entire case ended up turning on conflicting testimony from Lamar, one of the partners at the law firm, and Appling about a 10-year-old conversation where this tax refund was discussed, and they gave conflicting testimony about what exactly was said in that conversation. And so that's just an illustration here of why having something in writing would have made that clear and not had to rely on such tenuous evidence. Appling also argues that the law firm's position requires a difficult line drawing issue. The law firm concedes that a sufficiently detailed listing of someone's assets and liabilities would count as a statement respecting financial condition. So the question is, how detailed does it have to be in order to qualify? And here, Appling actually says Lamar knew the full financial condition. All of Appling's wealth was tied up in this business that the law firm had been hired to deal with, and his only other asset was this tax refund. So in effect, he had given them his entire financial situation. So he says that's his basic position. The law firm, on the other hand, argues that this very specific fraud about specific assets and things shouldn't be swept into this broad provision. They say that there's a general provision in bankruptcy that bankruptcy is supposed to only protect the honest debtor, and that when Congress made an exception to that, it should be treated pretty narrowly. And this is here's a quote from their brief. They say Appling's position would cover, quote, lies about whether one owns an asset offered for collateral, lies about how much that asset is worth, lies about whether the asset is unencumbered, lies about the existence or non-existence of specific debts, and so on. Any such statement, so long as it was made orally, is exempt from the anti-discharge rule. So they're arguing this just covers so much dishonest behavior that Congress never would have wanted to be exempt from the rule against discharging fraudulent debts. And they argue that there's also a line drawing problem under Appling's rule, that this broad reading of what is respecting financial condition would encompass potentially any type of fraud. For example, a debtor's statement that they have a particular professional license, which affects the income stream that they're going to have, which would affect their financial condition, or the fact that a debtor is employed in a particular manner, or has some certain source of income, would also affect their financial condition. And so they say that this just raises its own line drawing issue. So that's the issue in that case that the court's going to have to decide. So moving on, two more cases that the court's going to hear on Wednesday. I'll try and go through each of these quickly. The first case on Wednesday is called Washington v. United States. And this is a case about, it's a Indian tribe treaty. It's a series of treaties in 1854 and 1855 that the United States made with various Pacific Northwest Indian tribes. And as part of these treaties, they guaranteed, the United States guaranteed these Indian tribes access to fishing rights on rivers within the territory, and specifically to salmon runs. And some of the language from these treaties reads that they had, quote, right of taking fish at all usual and accustomed grounds and stations in common with all citizens. And this fishing right was actually one of the primary benefits these Indian tribes received in exchange for giving up land rights. Now, this was a suit brought by the federal government and more than 20 Indian tribes in the Pacific Northwest in order to enforce these treaty rights. This dispute has been going on for decades now. But based on previous decisions, it's undisputed that the tribes are entitled to access to fishing grounds, and it's been held that they're entitled to up to 50% of the annual salmon harvest. Now, what's at issue here is that the Ninth Circuit Court of Appeals had held that the treaty also guarantees the protection of the fisheries themselves. In other words, the salmon population. There's an obligation not just to allow the tribes to have access to some portion of the salmon harvest, but there's an obligation to not deplete the salmon population. And here the argument was, and the decision below was, that the state of Washington had played a role in the decrease of the salmon population, and that obligated the state to take steps to increase the salmon population in order to comply with these treaty rights. And specifically, the specific issue here is state roads and the culverts under these roads that allow streams and rivers to pass through the roads. And that many of these culverts that were installed when roads were built throughout the state of Washington don't allow fish to pass through. And so what happened was the lower courts ordered the state of Washington to replace culverts throughout a large portion of Washington state in order to allow these salmon to pass through across past these roads unobstructed. And Washington says that basically there's more than 800 of these culverts in the treaty territory that are covered by this order, and it would ultimately cost more than $2 billion to replace all of these with these larger, more state-of-the-art culverts that allow fish to pass through from one side to the other. And it applies to culverts on every state road within the treaty territory, although it does not apply to federal, local, tribal, or private culvert, only ones on state roads. Now, the state of Washington has a number of arguments in this case. The first, there's an argument based on the treaty right in the first place, and Washington basically says the treaty right, this idea that they have to maintain the salmon population doesn't have any basis in the actual treaty language, and that this kind of has huge implications for all water use in many northwestern states if they have this general obligation to maintain the salmon population under these treaties. The United States and the tribes, on the other hand, argue that the treaty basically assumed the existence of harvestable fish. The treaty signatories intended this protection to exist, and that Washington's position would basically allow it to gut the treaty right by completely, stopping the flow of fish in all the streams in the state. And that there are precedents from previous cases that hold that when fishing rights are at issue, that it includes the protection against a substantial depletion of the fish population. So that's on whether this basic underlying right exists. But part of the argument in this case is about the remedy, is about what's been ordered here. And Washington argues, basically they make very specific arguments about these culverts. They argue that this order, which requires them to replace all culverts within the treaty territory, requires them to replace culverts that will make no difference whatsoever to the salmon population. For example, on streams where there is upstream or downstream blockage of the stream by private culverts, culverts that are not on state roads, that are on private land, where because of this private blockage, there's no way for salmon to get through anyway. So replacing the state culverts makes no difference at all. And they claim that 90% of the state culverts are either upstream or downstream of non-state barriers that block the fish from going through. And they say there can't be any violation of the treaty rights if no salmon were able to pass through to begin with. And they also argue this basically wastes money that could go to more effective salmon recovery efforts. And they also argue that there's insufficient proof of causation of the decline of the population, that these culverts really are responsible for the decline of the salmon population, or that replacement of them would really increase the salmon population. And then finally, they argue that this remedy, this injunction, ignores the equities. Basically, they argue that the federal government was heavily involved in this road construction. They set requirements for road culverts, and they improved the specific culverts that Washington used decades ago. And then they've turned around now and sued the state of Washington to force them to replace them all. So they say that the government had a role to play in this happening, so it's not fair for all of the costs to be allocated to Washington to bear all of this burden. The United States and the tribes have come back on the other side and said that there is ample evidence in the record that the culverts caused the depletion, and that replacement of them will improve the habitat, and that this is just a effort by Washington to try and relitigate that issue after the fact at the Supreme Court, so that's the issue here, and it'll be interesting to see whether the court is more interested in the basic treaty issue of what does this treaty right require, and what is fairly implied by the language of these treaties, or if they're interested in digging into this remedy issue about the scope of the injunction here. There's one interesting note about this I mentioned previous week. Justice Kennedy is recused from this case due to his involvement in this case at an earlier stage over 30 years ago, when he was a judge on the Ninth Circuit. So the only 8 justices hearing this particular case. So now I'll move on to the last case of the week, of next week. This is a case called Lagos v. United States, and it's a case about the Mandatory Victims Restitution Act. Now, this is a federal law that requires the victims of certain crimes. It requires the convict, the person convicted of the crime, to pay restitution to the victims for certain categories of damage. And there's 4 specifically defined categories, but one is relevant here. It reads, lost income and necessary childcare, transportation, and other expenses incurred during participation in the investigation or prosecution of the offense, or attendance at proceedings related to the offense. So that's the provision here. Now, here are the facts of this case. The criminal defendant, his name is Sergio Lagos. He was convicted of wire fraud for deceiving the General Electric Capital Corporation about business income that he had in order to obtain loans. So basically, he owned some companies that had a revolving loan with GE Capital. He misled GE Capital about his business income in order to increase the size of these revolving loans. Now, eventually the fraud was revealed, and GE Capital spent money investigating it. They hired forensic experts, lawyers, consultants, etc. And then also these Lagos's companies declared bankruptcy, and GE Capital spent money participating in these bankruptcy proceedings. And the court below awarded restitution to GE Capital under this Mandatory Victims Restitution Act for the legal, expert, and consulting fees incurred by GE Capital investigating the fraud, and for their legal fees in the bankruptcy proceedings. And it amounted to almost $5 million combined for the investigation and legal fees. Now, the important thing is these fees were not related to the government's criminal investigation. These related to GE's own criminal investigation, and the proceeding involved was not the criminal proceeding, the criminal prosecution. It was the bankruptcy proceedings. So Lagos's argument here is that this doesn't fit with the language of the Mandatory Victims Restitution Act. When it refers to participation in the investigation or prosecution, it refers to the investigation of the offense, which is referring to the government's investigation. When it says the investigation of the offense, and it says the prosecution of the offense, it's clearly referring to the criminal prosecution. It's not talking about private actions that are not part of the government's prosecution. It also says during participation in the investigation or prosecution. So they say GE's investigation actually happened earlier. It happened before the government's investigation. And that just doesn't comply with the literal terms of the statute. It's not during the investigation or prosecution. They also argue that there's language where it describes the categories, the types of of damage, they say lost income and necessary childcare, transportation, and other expenses. There's a legal principle. This is a canon of interpretation. That just means it's a rule of thumb for interpreting legal language. There's a rule. It has this Latin name. It's referred to a justus generis. That's just the kind of Latin term that's applied to this, but that means it's just law Latin for the same kind. And the idea here is when you have a general term, in this case, it's a term like other expenses, just general term. When it follows a list of specific terms, then the general term should be interpreted and kind of limited to things of the same type. So here it says, lost income and necessary childcare, transportation, and other expenses. In that context, the argument is other expenses should be interpreted to mean these kind of costs related to the actual physical attendance of proceedings or meetings with the government investigators. So it's the actual costs of going and physically being present and participating in that way. It doesn't mean it should sweep in anything that could possibly be an other expense. And so that's the basic arguments on the language of the statute. They also, Lagos also argues that there's other restitution statutes where Congress uses much broader language than in this one. So Congress kind of knows how to be much broader when it wants to, but here it limited it to 4 specific categories, so it shouldn't be assumed to cover everything. And finally, there's another canon, another one of these kind of rules of interpretation. It's known as the rule of lenity, which specifically applies to criminal prosecutions. And it's the idea that when there's ambiguity or unclarity in criminal laws, that they should be resolved against criminal liability, so that unclear criminal prohibitions should be interpreted narrowly. And it is part of it. Part of this, the reason for this is the special need in when someone's going to be criminally liable for fair notice of what's covered and what someone will be liable for, and also to make sure that it's the legislature that's driving criminal punishment and not courts that are deciding what is or is not punishable when it's in the criminal realm. So those are the basic arguments that are made. On the other side, the government responds back and just says that there's lots of reasonable expenses that people would incur related to participation in investigations that wouldn't be covered potentially under Lagos's arguments. For example, would it cover legal expenses related to bringing an attorney to meetings with government investigators? If you read that the types of things that are covered under other expenses too narrowly, that would be excluded. It also argues that different restitution statutes just use very different language, and each one kind of needs to be interpreted on its own. You can't necessarily read the fact that one used broad language and others set out categories can't be used to infer that one is necessarily narrower or broader. And they also argue that the rule of lenity just shouldn't apply here because under the government's argument, there really is no ambiguity after you apply the kind of normal approach to statutory interpretation, which allows you to give this very broad understanding of other expenses. So that's the court will have to decide how broadly to read other expenses here, and whether these extensive costs related to private investigation can fit within this Mandatory Victims Restitution Act. So that's next week's cases. That brings us to the end of this live stream episode. Our next live stream will be a week from today. That's Thursday, April 19th, again at 9 p.m. Eastern time. That's our usual weekly live stream time, Thursdays at 9 p.m. Eastern. But you can always check the Counting to 5 YouTube channel to find the next scheduled live stream. Now, next week's live stream, the court has its next private conference tomorrow. That's Friday, April 13th. So there's a chance of newly granted cases in Monday morning's order list. There's also a pretty high likelihood that we'll get at least one or more opinions next week, just because the court has a big backlog of cases and we're starting to run out of time toward the end of the term. So if that happens, we don't know that it necessarily will happen, but if the court issues any opinions, it'll likely be on Tuesday or Wednesday next week, likely at 10 a.m. immediately before the day's oral arguments. So if there are newly granted cases or opinions, we'll definitely discuss those on next week's live stream. But also the following week, that's the week of April 23rd, the court will hear oral argument in another 6 cases. They have 3 on that Monday, 2 on Tuesday, and 1 last case on Wednesday. So next week's live stream, I hope to preview each of those 6 cases for the last week of the term's oral arguments. The highest profile case of that next week is one I already mentioned earlier, the Trump v. Hawaii, which is the travel ban litigation. There's always a possibility of emergency orders or other interesting developments. So we'll just keep an eye out and discuss whatever comes up. Whether you're watching on YouTube or listening to the audio podcast, I would love your feedback. You can leave comments on the show notes at countingto5.com, on the Counting to 5 YouTube channel or Facebook page. You can tweet at countingto5 or send an email to mike@countingto5.com. Please subscribe to the Counting to 5 YouTube channel or audio podcast to make sure you don't miss future episodes. And thank you for listening. This has been Counting to 5.